It looks like everyone is here. So let me just talk to you for a minute about the format. We have about an hour and a half slated for this first panel discussion. And the focus of our panel is going to be judicial engagement in the realm of individual rights. All right, so without further ado, we're going to go in order. So David, you start us off.
Okay. Okay, so my talk is about the conservative origins of strict judicial scrutiny and the traditional interpretation of the and it's about strict scrutiny in the due process context. And the traditional interpretation of the court's due process decisions during the so-called Lochner era of the early 20th century was that the court was seeking to protect a laissez-faire, social Darwinist perspective against ameliorative protective legislation. Sure, they claim to be relying on the due process clause and all the things that Randy just talked about, but in fact, any doctrinal justifications for what they were doing was a mere smokescreen for the court's reactionary anti-regulatory agenda. That simplistic and wildly inaccurate, in fact, view of what the court was doing has been challenged successfully over the last few decades by various revisionist historians who have come to a more sophisticated analysis of the Supreme Court's pre-New Deal due process jurisprudence. The most widely accepted revisionist thesis is that the court was, in fact, trying to combat what they call class legislation that distributed benefits or penalties based on arbitrary or unreasonable classifications that had no valid connection to the so-called police power. The primary advocate of this thesis is a professor named Howard Gilman, but it's become widely accepted by many others as well. Gilman, unlike the pre-revisionist predecessors, recognizes that the court was not only protecting economic rights, but also protected in some cases what we now call civil liberties or civil rights. But he argues that the Supreme Court's early civil liberties opinions were severely limited by the majority's refusal to invalidate laws as long as they were within the police power. So regardless of the claimed right at issue, according to Gilman, whether it was an economic right or a non-economic right, the court didn't distinguish in those days, which is correct, but regardless of what kind of right it was, the court would uphold legislation in question so long as the government could come up with a valid police power rationale for it. So despite the other differences between the modern revisionists and their predecessors about the origins of the court's New Deal jurisprudence, they do agree on one thing, which is that it was exclusively, if anybody, the progressive wing of the Supreme Court in the 1920s in the so-called Lochner era that planted the seeds for modern fundamental rights jurisprudence, and this was in opposition to the more limited view of fundamental rights that the so-called conservatives on the court had. So you had Justice Holmes and Brandeis writing these First Amendment dissents or freedom of speech dissents into the 14th Amendment, and what they said was, well, even if there's a police power interest here, the government still can't do this. So instead of having a police power test, we have a clear and present danger test, for example, a much stricter test. So I come today to challenge this understanding of the constitutional history. I argue that modern fundamental rights jurisprudence does not have its origins solely in these First Amendment opinions by the progressive wing of the pre-New Deal court, nor for that matter, as some people identify it, in the liberal majority New Deal era opinions like Caroline Products and so forth. But the origins also lie in cases from the 1910s and 20s written with the support of the conservative majority, such as Buchanan versus Warley, Atkins versus Children's Hospital, Meyer v. Nebraska, and Farrington versus Tokushige. In each of these cases, the court invalidated legislation as a violation of the Due Process Clause, even though the court acknowledged that the government had put forward a valid and otherwise valid police power rationale for the law in question. So the first key move was that the court shifted. I think Gilman is correct that the court was largely focused on the class legislation issue in the early part of what we call the Lochner era through the very early 20th century, the 1880s, 1890s. But I think the court made a move in 1905 in Lochner, and this is the real significance of Lochner historically, away from class legislation and towards focusing on individual liberty. If you look at Lochner itself, there are a lot of reasons why the court should have focused on class legislation, including the fact that if you read Lochner's brief, it's all about class legislation and barely mentions liberty of contract. But the court, almost complete, in an opinion by Justice Rufus Peckham, almost completely ignored class legislation and instead relied on the right to liberty of contract. This set up the Due Process Clause as being a fertile source for the protection of liberty rights against the states. But as Gilman points out, this was at least at first limited because the court said, well, whatever liberty rights you have are limited by the scope of the police power. Even in Lochner itself, Justice Peckham acknowledges that if indeed you could come up with a valid public health rationale for the law, or even a valid rationale as to why this law that was limiting the hours of bakers would protect the baker's public health, own health, if the bakers really needed some protection, then the law would be valid. Putting aside Holmes's radical for its day opinion that the court has no business getting involved in this to begin with, the dispute between the majority and the dissent was simply over whether there was a valid public health rationale or health rationale for the bakers in this case, not whether there was, in fact, a very important right to liberty of contract. But this deference to the state's police power began to break down fairly quickly. And now we can go to the first slide. The first case that I want to talk about is Buchanan versus Warley, a 1917 case. In Buchanan, the Supreme Court unanimously invalidated a Louisville, Kentucky law banning whites from buying property on blocks with a majority of black property owners and vice versa. In defending Louisville's law, Kentucky put forward a variety of police power rationales, at least some of which the court said were indeed valid police power rationales. The most obvious one was the court said, look, there's a lot of racial violence going on in the United States. We have race riots in East St. Louis that killed dozens of people. Keeping whites and blacks separate will prevent interracial violence. And the Supreme Court took that rationale, among others, and said, yes, those are valid police power rationales. The state does normally have the ability to try to protect the public peace. And this is not an unreasonable way of doing it, but it's nevertheless not a legitimate exercise of the police power. And it is because it is in direct violation of the fundamental law enacted in the 14th Amendment of the Constitution, preventing state interference with property rights except by due process of law. Now, one could easily say, well, that's just an anomaly because Buchanan versus Warley, as a case involving race segregation, was so close to the original purpose of the 14th Amendment, the overwhelming purpose. There are other purposes too, but everyone agrees that a primary purpose was to protect the rights of blacks, so maybe that was just an anomaly. But then there are other cases like this. Now we could go to the next one. In Atkins versus Children's Hospital in 1923, infamous case invalidating a minimum wage law for women only, Justice George Sutherland, speaking for a 5-3 majority, concludes that freedom of contract is the general rule and restraint the exception, and note, abridgments of freedom of contract can be justified only by the existence of exceptional circumstances. So a mere police power rationale is not enough. It has to be an exceptional it has to be something exceptional that the government's trying to do. That same year, in Meyer versus Nebraska, the court invalidated as a violation of the 14th Amendment's Due Process Clause a Nebraska law that prohibited the teaching of foreign languages to children. Nebraska justified the law as being necessary to assimilate recent immigrants. And the court didn't dismiss that as a valid concern. Indeed, Justice McReynolds, writing for the court, acknowledged that it is clear that the state may do much, go very far indeed, in order to improve the quality of its citizens physically, mentally, and morally. But he cautioned that the state's power is limited by fundamental rights that must be respected. The protection of the Constitution, he wrote, extends to all, to those who speak other languages, as well as to those born with English as on the tongue. Perhaps it would be highly advantageous if all had ready understanding of our ordinary speech, but this cannot be coerced by methods which conflict with the Constitution. A desirable end cannot be protected by promoted by prohibited means. So instead of holding, as the court did decades earlier, that the liberty rights under the 14th Amendment are limited by the scope of the police power, the court is holding in Meyer that exercises of the police power are limited by the scope of fundamental liberty rights. So that's a big change. Similar reasoning produced a similar result in Farrington versus Tokushige. Farrington involved a challenge to a law designed to prevent the teaching of Japanese in schools in Hawaii. Once again, the court seemed to acknowledge, yes, we have all these Japanese people, they may be loyal to the empire and all that, but still, even though you have this valid police power concern about assimilating the Japanese, you can't interfere with their right to teach their children Japanese. That's just part of their inherent fundamental rights. In none of these cases, of course, did the court actually adopt the modern fundamental rights strict scrutiny analysis, but that doesn't really defeat my point. Various law professors and historians have tried to figure out exactly when modern fundamental rights strict scrutiny came into effect, and they target approximately 1963. So you wouldn't expect, of course, in 1923 or 1927 the court to have created exactly that test, but my point is not that these decisions directly anticipated exactly the test that we have today for fundamental rights under the Due Process Clause, but rather that modern doctrine had some antecedents in opinions produced by the pre-New Deal court's conservative majority. The existence of these precedents shows that the Supreme Court's pre-New Deal jurisprudence was not always in favor of upholding laws that infringed on liberty rights so long as the state asserted a valid countervailing police power interest. The police power does seem to have limited the court's enforcement of liberty rights at the beginning of the 20th century, but by the 1920s, the court had clearly grown dissatisfied with its constriction and concluded that states may not infringe on certain fundamental rights even if they are acting within the police powers. So traditional history has it that, well, the court had this narrow view of rights, but it protected economic rights and maybe did that too much, but it was first Justice Holmes and Brandeis and then Caroline Products and Palco versus Connecticut, which set forth this idea of fundamental rights and true protection of rights as trumps. And that, and my view is that this is not the case, not that they didn't do that, but that this also had antecedents in the conservative majority's jurisprudence, so that the real change in the New Deal period and beyond that was not the idea of fundamental rights versus non-fundamental rights, or that the idea that police power always is a limit on rights or not, but the idea that economic rights are just banned from being considered fundamental rights subject to any significant scrutiny. Thank you.
Good morning, everyone. It's a pleasure to be here. My thanks to Elizabeth Price Foley and the Institute of Justice for putting on this conference and for inviting me to be a part of such a wonderful group of scholars. It's a special pleasure to be on a panel with David and Eric, whose work I admire so much. And it's great to come after Randy. I enjoyed his presentation this morning. Randy is someone who's been fighting the good fight of judicial engagement for some time. And my admiration for Randy is not diminished in the least by the fact that he's often fighting against me. But not so much, not so much anymore. I mean, if you remain in this profession for some time, you get to know people and you get to know their ideas. And Randy and I, who when we first began to engage on Ninth Amendment issues, and had a few disagreements here and there, over time we found ourselves agreeing more and more to the point where really I think we almost completely agree on the issue of limited federal power. And so it's a pleasure to listen to Randy this morning. And it's appropriate to have this first panel, too. Randy's work, of course, primarily has to do with the protection of individual liberties. And so in this conference on judicial engagement, you begin with a panel talking about individual rights and the court's approach, the court's engagement with the protection of individual liberties. In some ways, though, I'm a bit of an anomaly being on this panel. My work primarily has to do with federalism. The history of federalism and the general autonomy, the constitutional protection of the autonomy, regulatory autonomy of the people in the states. And I imagine that federalism and that constraint on federal power is probably going to be a subject that's going to be addressed on the following panel. But I'm glad that I'm on this panel, though. because it's going to give me an opportunity to talk about the relationship between federalism and the protection of individual liberty. So what I'd like to do this morning is spend a little bit of time talking about the nature of individual rights and liberty under the American Constitution, and then spend a little bit of time talking about how federalism as a liberty, as one of the people's liberties, is actually written into the text and the historical construction of the Constitution. Now, rights talk, generally, when we engage in these type of conferences and these kinds of discussions, it generally focuses around issues of individual rights. Rights that can be successfully accomplished by an individual person themselves. So you would be talking about free exercise of religion, or maybe the rights of personal expression, the right to bear arms, and the discussions might revolve around whether or not we ought to recognize a particular individual liberty, or if we do recognize it, what level of scrutiny ought the courts apply to that particular liberty. As a matter of constitutional text and constitutional history, however, individual liberty under the Constitution is actually a far broader concept, and it's one that includes the exercise of majoritarian and political or collective liberties and rights as well. The cry of no taxation without representation. That's not an assertion of the individual right not to be taxed. That's an assertion of the right to be taxed within the context of a majoritarian political representative context. Similarly, the right of the people to alter or abolish their system of government, as declared in the Declaration of Independence. This is a right that cannot be exercised by an individual person, but actually is a person gathering with others, and can only be exercised by the people in the collective. Finally, the American doctrine of federalism, the idea that the people in the several states retain the right to exercise majoritarian political control over all matters not given into the hands of the national government. This too is a collective or a majoritarian right. All of these rights, and also personal individual rights, but all of these majoritarian and collective rights are enshrined in one way or another in the Constitution itself. You have the representative provisions of Article 1, you have the amendment provisions of Article 5, and you also have the textual declaration of federalism, most commonly associated with the 10th Amendment. But despite their textual pedigree, and really their historical pedigree as well, these majoritarian and collective rights tend to remain on the sidelines whenever you're having discussions about individual or American liberties. And in fact, some scholars, and courts as well, question whether or not these rights ought to be judicially enforceable at all. For example, the Supreme Court at times has suggested that the rights to local self-government, or federalism rights, recognized by the 10th Amendment, are not really subject to any kind of judicial enforcement, but actually ought to be left to the simple structural protection of the Constitution and the political process. Now, this kind of judicial non-engagement might be appropriate if you believe that these kinds of federalism rights have little, if anything, to do with individual freedom. But that, of course, is a disputed proposition. And in fact, the Supreme Court has quite recently declared that federalism and the rights of local self-government are as much a part of individual freedom as any other freedom listed in the Bill of Rights, or the first 8 amendments. And here I'd like to quote from Justice Kennedy in the recent opinion Bond against the United States. In Bond, the court ruled 9-0 that an injured individual had standing to challenge federal laws that violate the principle of the 10th Amendment. And in explaining why an individual might have standing to challenge a federal violation of state autonomy, Justice Kennedy declared, "The federal system rests on what might at first seem a counterintuitive insight, that freedom is enhanced by the creation of 2 governments, not 1. The framers concluded that allocation of powers between the national government and the states enhances freedom, first by protecting the integrity of the governments themselves, and secondly by protecting the people, from whom all governmental powers are derived. Federalism is more than an exercise in setting the boundary between different institutions of government for their own integrity. Federalism secures to the citizens the liberties that derive from the diffusion of sovereign power." And then finally, just to drive home the link between local self-government and national rights, Kennedy declared that by denying any one government complete jurisdiction over all the concerns of public life, federalism protects the liberty of the individual from arbitrary power. When government acts in excess of its lawful powers, that liberty is at risk. Kennedy's opinion in Bond clearly and strongly presents federalism as a constitutional liberty of the American people. And in fact, it's one of the strongest defenses of federalism that's come forth from the Supreme Court in decades. And therein lies the problem. In many ways, Kennedy's decision in Bond lies in substantial tension with other recent Supreme Court decisions that take a more deferential approach to national power in cases affecting the interests of the states. You can see this deference in the Raich opinion, in which the court denied California the right to authorize the non-commercial medicinal use of marijuana. You can see it in the Comstock case, which seems to apply the lowest standard of review to Congress's own construction of the necessary and proper clause, a case, by the way, that cited Lee Optical, the Supreme Court's opinion in Lee Optical. In many ways, the modern court seems unsure whether federalism is simply a good idea that Congress ought to respect, or whether federalism is in fact a constitutional right of the people that Congress must respect. And only the latter would obligate the courts to actively patrol the boundary between state and local power. Now, what I want to do with my remaining time is suggest that there's actually good reason to follow Justice Kennedy. And his suggestion in Bond that federalism is not just a good idea, but is a constitutional and judicially enforceable right of the people. So let's begin with the text of the Constitution itself. A text which actually announces that federalism is a retained right of the people. And it does so not just in the 10th Amendment, which is the text normally associated, or most commonly associated with the idea of federalism, but it's also found in the 9th Amendment as well. As Randy had just quoted, the 9th Amendment declares that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, ordinarily, and I think most commonly, we would associate that text with individual rights, and only individual rights. But that really reflects more our tendency to think of rights in an individual capacity in general. The men who framed and ratified that text, however, had a far more expansive view of what actually counted as the retained rights of the people. James Madison, the founder, who actually drafted the initial versions of the 9th and 10th Amendments, insisted that these two amendments worked together in a manner that prevented the federal government from reaching into matters that were meant to be left to the people in the states. In his speech opposing the First National Bank, for example, Madison insisted that the power to issue charters of incorporation was a matter retained as a matter of right by the people in the several states. Now, when he made this argument, it triggered objections from his colleagues. It would be one thing to say, well, we simply don't need a Bank of the United States, or it would be inexpedient for us to have a bank, or it's a question of political controversy. But Madison was not making an argument of expediency. Madison was saying that if you actually issue this charter, you're going to be violating the people's constitutional rights. And that, according to Madison's colleagues, was objectionable. Surely he had gone too far by asserting that this was a matter of rights. In response, Madison pointed to the language of the 9th and 10th Amendments. He reminded the House of Representatives that the states had ratified the Constitution with the expectation that federal power would be narrowly construed. These promises of limited federal power were about to be enshrined in the text of the Constitution through the adoption of a Bill of Rights, which was then pending before the states. Madison then read several of the proposed amendments, remarking particularly on the 11th and 12th, what we call our 9th and 10th Amendments. The former, the 9th, as guarding against a latitude of interpretation, and the latter, the 10th, as excluding every source of power not within the Constitution itself. Now notice that Madison describes the 9th Amendment as guarding against a latitude of interpretation. Put another way, the 9th Amendment guards against an overly broad interpretation of national power. The 10th then declares that all powers denied to the federal government are reserved to the people in the several states. And working together, the 9th and 10th Amendments guaranteed the people's retained right to local self-government. Protecting the people's retained powers and rights meant leaving all of these retained matters under the political authority of the people in the states and their political representatives. Madison thus closed his speech against the bank bill by insisting that the proposed charter would, quote, level all the barriers which limit the powers of the general government and protect those of the state governments. Madison was not alone in believing that the 9th and 10th Amendments worked together to preserve the federal structure of the American Constitution, and did so as a matter of right. For the next 100 years, every legal commentator that addressed the Ninth and Tenth Amendment viewed them as working together in protecting the federalist structure of the United States government. St. George Tucker, in his 1803 treatise, A View of the Constitution, wrote that when the Ninth and Tenth Amendments were combined, quote, the sum appears to be that the powers delegated to the federal government are in all cases to receive the most strict construction that the instrument will bear, where the rights of a state or of the people, either collectively or individually, may be drawn into question. As one of the people's retained rights, one would expect that this federalist separation of state and national power would be closely guarded by the court, and is as closely guarded as any other right listed in the Bill of Rights. And the last thing you would want would be the federal government itself left in charge of defining the scope of its own power. And it's precisely for that reason that James Madison objected to John Marshall's opinion in McCulloch against Maryland, which upheld the Second Bank of the United States. In McCulloch, Marshall had implied that the people of the United States existed only in a unitary national form, and not in their sovereign capacity in the separate states. This meant that there were no retained rights of the collective people in the states that Marshall was obligated to protect. And that being the case, Marshall believed that it was perfectly appropriate to generally defer to Congress's interpretation of its own power, at least when nothing more than purported state autonomy was at stake. In his detached memoranda, Madison dismissed Marshall's erroneous views of the Constitution in McCulloch against Maryland, and in particular, Madison objected to the Chief Justice's expounding power of Congress as if no other sovereignty existed in the states, supplemental to the enumerated powers of Congress. To Madison, not only had the independently sovereign people in the states ratified the Constitution, they continued to exist and served as essential brakes to the otherwise unstoppable power of the national government. It was especially wrong, therefore, wrote Madison, that Marshall had suggested that the court should play little, if any, role in enforcing the line between federal and state power. That kind of judicial deference cut against the very reason we have a Bill of Rights in the first place. In fact, in his speech introducing the Bill of Rights to the House of Representatives, Madison explained that by adding that bill, quote, independent tribunals of justice will consider themselves the guardians of these rights, and would resist every encroachment upon rights expressly stipulated in the Constitution. Judicial protection, judicial engagement, was to extend to the entire bill, not just the first 8 amendments, but to the 9th and 10th amendments as well, provisions meant to preserve the people's retained rights to local self-government. Now, one obvious objection to the story that I've kind of laid out here, the story about federalism at the time of the founding, is that that wasn't the end of our American history. You could point to the Civil War and point to the addition of the Reconstruction Amendments, which substantially constrained the previous autonomy of the states. And in fact, a number of scholars have argued that the Federalist system, the old Federalist system, was washed away in the new birth of freedom that occurred after the Civil War. In fact, although today we tend to associate the Union victory over the slaveholding South as a victory of nationalism over federalism, the reality is actually far more complicated. It was the slaveholding states, after all, that rejected the concept of state rights and sought to impose chattel slavery as a national right that would allow them to carry slaves into every state in the Union. The infamous Dred Scott decision was a step in the direction of nationwide slavery, and it was unduly broad nationalist interpretations of power in cases like Dred Scott and Prigg against Pennsylvania that threatened to snuff out the few jurisdictions where the people exercised their rights of local self-government and rejected slavery. In the aftermath of the Civil War, the moderate Republicans who controlled the construction of the 14th Amendment believed that they were restoring the proper balance of state and federal power, a balance that had been violently skewed by the slave power. Even as they sought to enshrine new rights against state action, they remained committed to the preservation of federalism and the local control of all matters not expressly delegated into the hands of the national government. According to John Bingham, the man who framed Section 1 of the 14th Amendment, it was, quote, our dual system of government by which our own American nationality and liberty had been established and maintained. Although Bingham supported an amendment that would force the states to protect the Bill of Rights, he resisted any effort to give the federal government, including the federal courts, power over the general content of civil rights in the states. And as much as the 14th Amendment imposed new and important constraints on states' authority to interfere with constitutionally protected rights, nothing in that amendment or the intentions of the man who drafted it altered the fundamental principle that the people retain the rights of local self-government in all matters not expressly denied to the states somewhere in the text of the federal Constitution. All right. In conclusion, the Supreme Court continues to struggle with whether it has some role to play in maintaining the line between federal and state authority. In cases like Lopez and Morrison, the Supreme Court has tried to fashion a line between local commercial and local non-commercial activity. And as was the case for the Supreme Court's earlier distinction between direct and indirect impacts on interstate commerce, scholars have criticized the commercial-non-commercial distinction as an unrealistic and perhaps even incoherent attempt to determine where the effects on interstate commerce begin and end. But this criticism misses the point of drawing the distinction in the first place. Drawing a line between matters local and matters national is not required by some theory of economics or social utility. As with all lines drawn by the Supreme Court in its jurisprudence of individual freedom, these distinctions are drawn in order to secure an area of autonomy over matters never meant to be given into the hands of the national government. If these rights are to be maintained, the judiciary has no choice but to engage, and to engage in the difficult task of line drawing. We expect that engagement when it comes to individual rights in the first 8 amendments, and we have every bit as much right to expect judicial engagement when it comes to the last 2 amendments in the bill. Justice Kennedy recognized as much in Bond against the United States, and here's hoping that the court will continue to follow Kennedy's lead, even when there is more at stake than the mere recognition of party standing. Thank you.
I want to join with my colleagues, Kurt and David, in thanking the Institute for Justice for hosting this event, and thanking Elizabeth Price Foley for inviting me to speak, and thanking the GMU Law Review for publishing the proceedings of the symposium. I'm recovering editor-in-chief, and I know that it is a lot of work to publish a symposium, and I hope I haven't imposed too much work on the editors. The title of my published article will be Judicial Engagement and Civic Engagement for Case Studies. And I guess I want to spend a little time explaining the motivation for the talk and then summarizing the general intentions of it, and then I'll read the takeaway at the end, and I hope then to sit down. So, like Winston Churchill, paraphrasing him, I think this is a modest piece and it has a lot to be modest about. David and Kurt have given you pieces that exemplify or embody what they're working on in their most recent scholarship. I wasn't that crafty or self-promoting. I thought instead to, pardon the pun, engage the topic of the symposium and maybe give some constructive criticism to IJ as they go forward with the Center for Judicial Engagement. And I guess I'm also in part drawing on lessons that I've learned from teaching a course offered here at the George Mason University Law School. We have offered a course called Constitutional Law, the Founding, for several years to the first-year class. And last year we made the program and the content cover more American constitutional history after the ratification of the Constitution. So I think there are some useful and relevant lessons here, but the editors of the Law Review, if you wanted to know last year what was in the teacher's manual, you're going to get a peek. So here's why I want to say that I'm not so sure what I'm saying is novel. I think a lot of the themes I'm about to talk about have been discussed in other areas of scholarship, and they're known about in some parts of contemporary public discourse by policymakers and lawyers. A lot of the basic concern I have about touting judicial engagement is that I wonder how much impact or how much judges can change the law if they get out ahead of opinions of the public, and I think especially the opinions of opinion shapers among legal and policymaking elites. And this theme is something that's known among public interest lawyers. They know about the debate between Thurgood Marshall and Martin Luther King. Should the resources of the NAACP and other groups protecting the rights of African Americans be devoted towards litigating in the federal courts or devoted to boots on the ground or door-knocking strategies, grassroots advocacy, and the political processes. And paralleling that debate among lawyers and political activists, there's a debate in the political science literature. Some political scientists see, there's a conventional wisdom in which Brown versus Board of Ed encapsulated or confirmed the wisdom of the Thurgood Marshall approach, and then Gerald Rosenberg wrote a book called The Hollow Hope, suggesting that most of the civil rights successes were attributable more to the grassroots efforts of Martin Luther King and his allies. And a lot of these same themes you could get from reading a good constitutional law textbook that has a lot of history, like the Brest-Levinson casebook and the McConnell-Paulson-Calabrese casebook. But that said, if judicial engagement becomes a new topic of constitutional scholarship, while it's on the ground floor, it might want to take cognizance of themes that have been tested and discussed and argued in other applicable scholarship. So at the minimum, I know I'm doing the service of bringing the judicial engagement debate into contact with relevant other debates. So what I guess I'm trying to do more than anything is to provide a very quick and dirty reminder about 4 episodes in American history where courts may or may not have been engaged, depending on how one construes engagement, but political actors were sure as anything engaged about the meanings of constitutional provisions. And the 4 episodes I think by now they've all been mentioned in previous remarks. So one of them is the debate about whether the Sedition Act, enacted by Federalists in 1798, was constitutional. And the 1800 election more or less settled that. The new Jeffersonian Republican Party ran on the platform that it was unconstitutional, and Jefferson, when he became president, pardoned people convicted under the Sedition Act and shut down convictions still, or prosecutions still ongoing. Another debate is the one that Kurt was talking about, the debate over the constitutionality of the National Bank. This debate started as soon as the new Congress was convened and set up its organizing rules of the first Congress. It wasn't settled really until the middle of the 1830s, when the second national bank was up for reauthorization, and President Jackson vetoed it, and then took all steps to try to have funds withdrawn from the banks and to make the bank ineffective. So to tell the story of the bank, one must tell the story not only of Madison, as Kurt did, but also somebody who is as mean and as feisty and as political as Jackson was. I was reading, as luck would have it, I was reading the newspaper this morning, and there was a quote from Jackson on page 2 of the newspaper, and it was him saying in 1837, just before he left office, saying he only had 2 regrets being president. One was not shooting Henry Clay, and the other was not hanging John Calhoun. So he was engaged, when somebody that ornery saw a bank he didn't like, too bad for the bank. The third debate is the debate over Dred Scott. The Supreme Court basically said to the newly formed Republican Party, your main political goal to restrict and prevent the extension of slavery into the federal territories is unconstitutional. Just pack up, go home. What you're trying to organize to do is unconstitutional. And the Republican Party did not acquiesce in that understanding of Dred Scott, and that was a major issue in 1860 and a major issue framing the stakes in the Civil War. And it was also, the 13th and the 14th Amendments were both written in part to repudiate and to overrule different aspects of the Dred Scott decision. And the last is the New Deal. And in the longer version of the paper, I treat 2 different understandings of the New Deal. One of them, I think, is the more common popular account. In this one, a Supreme Court constituted of the Lochner justices, the kinds of justices who agreed with the principles embodied in cases like Buchanan versus Worley, talked about by David, had made a show of resistance against the first New Deal in substantive due process case law, in cases about the contracts, no, not the contracts clause, about takings, and especially about the Commerce Clause, and then a few other cases about separation of powers. And the Democratic Congress and President Roosevelt ran in 36, in part against the court. And then after he won resoundingly in 1936, and once he was reelected, Roosevelt then tried to pack the court in 37, and the Supreme Court in one major due process case and another major Commerce Clause case turned about face. I covered that account, and I also cover another account, that a revisionist account that's been made popular and to me persuasive in the last decade or 15 years. It's been, I'd say the two people I'd give pride of place to are Ted White and to Barry Cushman at Virginia. Their account is an internalist account, and in their account, even in the period 1890 to 1935, the justices who agreed with the theory of government that Randy was describing and David was describing, in a lot of closed cases at the margins, made concessions to states regulating property and contract more than Justice Cooley's constitutional limitations would suggest. And they made concessions to the federal government's asserting testing the limits of its federal powers more than some of the narrower Commerce Clause decisions would suggest. And so I just lay out the facts, or try to provide a quick summary of these historical episodes. And I'm doing so to try to bring out answers to 2 or 3 questions. One question is, in these cases, how easy was it for judges to be engaged in the sense that they could see and figure out what the controlling law under the Constitution really was? Next, I'm asking, in these cases, did they step up and be engaged? And understanding that there's some ambiguities in what engagement means. And then last, I ask, when judges knew what the Constitution meant or what the law of the Constitution required and were engaged, how engaged or entrenched or stubbornly defiant or resistant were political actors. And my basic answers are, in some of these cases, I think the law was tolerably clear, but others it wasn't, not by a long stretch. And next, I guess in the cases where the courts thought they knew what their duty was and did it, they got rolled. So I guess the takeaway then is, I'm not out and out opposed to the idea of deploying a lot of resources to encouraging judicial engagement, but I want to offer a friendly but sobering warning to the supporters of the Center for Judicial Engagement: be careful what you ask for. And also, you might want to think about the comparative advantages of supporting judicial engagement versus civic engagement. So I guess in the time remaining, I'll try to explain those general reactions a little bit more systematically. And my first point, and my most important point, I think, is that there's no reason in principle why political officials and leaders cannot be as engaged as the Center believes that judges should be. Members of Congress took ownership of constitutional questions in all 4 of these episodes, and so did presidents. In some cases, so did states, and in some cases, so did political parties. So in the Sedition Act, Jefferson led the forming Republican Party and state legislatures to pass resolutions that protested against the Sedition Act, and these state legislatures and the Republican campaign organization forced the constitutionality of the Sedition Act to the political table, and that settled, the 1800 election settled these issues. And by contrast, there were not many court decisions about the constitutionality of the Sedition Act, and those that there were upheld the act, and for reasons I can talk about in question for answer, as a matter of legal doctrine, knowing the background principles of the time, courts were by no means crazy or flatly wrong in upholding the Sedition Act. Next point. So at least in the most contentious political disputes, when engaged courts go head-to-head with engaged political actors win hands down. And it's always good to remember here, Federalist 78, it described the federal judiciary as the least dangerous branch to the political rights of the Constitution. Congress has will and direction of the wealth of the society. The president has force, dispenses honors, and holds the sword of the community, but the courts have merely judgment. And I think the 2 episodes that confirm this the most would be Dred Scott and also the externalist account of the New Deal, in which the early New Deal court stood against the Roosevelt administration's attempts to pass a New Deal that expanded the scope of the Commerce Clause. Third, judicial engagement has a downside. I wholeheartedly agree that the advantages of judicial review outweigh its disadvantages, but you can't be blind to the disadvantages. So, for one, the power courts have to conduct judicial review can always generate a Dred Scott. In addition, if federal courts have a responsibility or a duty to be engaged, engagement can produce backlash. So if one thinks that some of the Commerce Clause cases handed down between 1890 and the early 1930s created a colorable basis for saying that many enactments of the Congress from 1933 to 1937 exceeded the scope of the Commerce Clause, judges should construe the Constitution and the Commerce Clause in light of those precedents and do their duty, but they run the risk of forcing a crisis where people say, well, if the Supreme Court's right about the Constitution, then the people by a 60 to 39% electoral vote in 1936 say too bad for the Constitution. And last, judicial engagement may sound nice in theory, but it's actually very difficult in some cases to implement in practice. And there are two reasons for this, at least. One is simply that I am more skeptical than many that judges can decide cases independent of the narrow partisan political context, but then maybe the more comprehensive intellectual context in which they operate. So the Dred Scott case certainly seems a case where partisan political context drives things. If you read Taney's opinion and parts of Taney's opinion about Congress's power to legislate about slavery in the territories, it has a lot of resemblances to John Calhoun's theory of the concurrent majority. And that seems very partisan. But to me, the more interesting case study is the New Deal, and especially the internalist account of the New Deal. In my read of things, the American constitutional law had a really, and the scholarship about it went through an extremely fertile period starting around 1890 or 1900. And there were a lot of academics proposing a new way of understanding the responsibilities and the priorities of state governments, the relationship between legislative majorities and courts, and the relationship between the states and the federal government. And there were practical developments going on at this time that pushed to the Supreme Court issues. For instance, the Interstate Commerce Commission. The Interstate Commerce Commission claimed the power to regulate state rates and preempt in-state railroad rates as a necessary and a proper adjunct to its power to guarantee rates for interstate rail travels. Cases like those were seized on by academics who were debating about the direction constitutional law should take to say that there's a broader understanding of the Commerce Clause and a broader understanding of national powers. And those ideas being rooted in scholarship in the period roughly 1900 to 1930 started to percolate in cases in that period, so that by the time the New Deal crisis happened in the period 1933 through 1936, you could say quite legitimately that the case law was so inconsistent that the game was no longer worth the candle. There's too much inconsistency in the cases trying to maintain the limits between federal and state power in the ideal form that Kurt was talking about to make it worth the effort to do so, and the courts just might as well back off. And that process shows you that judges can be unknowing carriers of developments in elite theory, especially elite academic theory. And if that process of percolation from elites, from academics to elite opinion among policymakers to the law is a real phenomenon, I'm more skeptical than Randy and others are that even judges who say, yes, sign me up, I want to be engaged, what do I do? I'm not always sure they're going to know what to do, because when they try to find out, get their bearings in light of the scholarship and the law, there'll be very polarizing and profound different opinions about what the law of the Constitution is. And I don't think that judges can decide cases in ways that are going to make a difference over the long haul. So to me then, what's most interesting about the center and what has the most promise about the Center for Judicial Engagement is the work that will be done to try to explain what the law of the Constitution is and ought to be. But to me, the greatest payoff is to make an impression on people in think tanks, opinion journal op-ed writers, academics, and get them to then be arguing about what the Constitution ought to mean. And then if they have a healthy discussion that persuades educated consumers of elite thought, those consumers then make a difference in politics. So one way or another, I think that the struggle or the pursuit of judicial engagement might have to proceed through civic engagement with political, public, and elite opinion. Thanks.
Okay, we're going to try to get a little discussion going amongst the panelists, and then we'll save at least, let's say, at least 20 minutes for some audience questions. Okay. I guess I'd like to just sort of start the conversation by picking up on something that Randy talked about in his keynote that I think all of these interesting panelists that we have before us are going to have different opinions about. First, let me just clarify. All three of you gentlemen would self-identify as some form of an originalist, correct?
Yes.
David?
Yes.
My only question mark, David. Yeah. I don't know, yeah.
A constitutional narcissist.
That's a new category. All right. Well, with one constitutional narcissist and two self-identified originalists, I think the question still might be intriguing. And that is, you know, because our topic is judicial engagement, specifically in the realm of individual rights. The most glaring thing that's occurred, you know, in the since the 20th century is this bifurcation of rights, right, between fundamental, non-fundamental, economic, non-economic, however you want to describe it. But we have a clear bifurcation, and that bifurcation has, you know, serious consequences in how courts go about analyzing rights-based claims. And if we are originalists, if we do, even if we're not an originalist, but we care about the text, right? We have a text that says in the Ninth Amendment that we shouldn't disparage rights that are retained by the people that haven't been enumerated in Amendments 1 through 8. So just working from that text outward, does not this bifurcation with its higher level of scrutiny for fundamental / non-economic rights, its lower tier of scrutiny for economic / non-fundamental rights, doesn't that disparage those rights? And how can the courts get away with that?
You know, it's a sort of interesting thing because I don't see any real popular sentiment that suggests that if the court was to engage in what I would think of as serious but limited judicial engagement on economic rights, for example, prohibiting takings that really, you know, the kind of thing where you buy a beach house and the government decides, well, we're going to require you to have we're going to require you to let all the local residents trample over your property on the way to the ocean with no compensation, or the kind of litigation IJ often brings where we try to prevent the government from forcing a hair braider to take 2 years of cosmetology classes, or an eyebrow threader from taking 2 years of cosmetology classes, or an inner city minister can't sell caskets to protect the monopoly of the mortuary industry. I don't see that there'd be any real objection politically. That anyone would really, I think those, in fact, IJ has been very successful when they lose these cases in the attention they get. So this is people say this is outrageous, and the city council or the state or whatever actually has repealed a lot of these laws. So it's talking about what going back to what Eric just said about civic engagement and the elite. The real problem is that both conservative judicial jurists and liberal jurists have this notion that we have to respect this New Deal settlement that Randy was talking about, and the New Deal settlement is in part that economic rights get no weight because, God forbid, we should somehow return to Lochner's. Of course, this is my big thing in my work, that Lochner plays this overarching and ridiculously oversized role in our discourse. But the funny thing about that is that the New Deal settlement, as opposed to the post-New Deal settlement, the Warren Court didn't say that economic rights get no scrutiny whatsoever. They said they get this rational basis scrutiny, which left some room open for the courts to review particularly egregious violations of those rights. Even Justice Holmes joined the majority opinion in the famous takings case that I'm now blanking on. Pennsylvania Culver, right, versus Mahone. So even Justice Holmes was occasionally willing, despite his skepticism. So I think it's less a matter of. I think there's no historical justification for the bifurcation. There's no originalist justification. There's no textual justification. There's not even a political justification. It is the self-image of judges that we would be doing something wrong if we engage with these issues in some way.
It's a great question. Where does the divide come from in terms of fundamental, non-fundamental rights? It's not in the text of the Constitution. And Elizabeth, I think you're exactly right that the Ninth Amendment suggests that there's something wrong. There's something illegitimate about this bifurcation. I would disagree a little bit with David about whether or not there's a political justification for it, because if you look at the historical source of this division between fundamental and non-fundamental rights, it comes from the time of the New Deal. And what's happening at the time of the New Deal is the pushback that Eric was referring to. You had a court that had been engaged in striking down very popular legislation, or at least legislation that was popular with national elites, and the court was in danger. The court was in danger of getting pushed back, even if there wasn't going to be a court packing plan, even if FDR wasn't going to be able to make that popular enough to enact. There was quite likely going to be some type of pushback by Congress, perhaps in the form of a proposed amendment that would allow Congress to override the decisions of the Supreme Court. So the Supreme Court was facing a substantial amount of political pressure, and as it backed away, and it did this over time, over a series of decisions, but you certainly see it in Carolyn Products, and I think you also see it in West Virginia Board of Education against Barnett. You see the court taking the position of, well, perhaps we have been wrong to be judicially engaged and engage in judicial review when it comes to non-enumerated rights like liberty of contract. That's not found anywhere in the Constitution. So perhaps we'll give that one over to the control of the political process. Perhaps we'll give economic regulation over to the political process. But perhaps we still have a role when it comes to certain fundamental rights actually expressly articulated in the text of the Constitution. And you can find that reasoning in footnote 4, and again, it becomes the basis of the opinion in West Virginia Board of Education against Barnett. So this division between fundamental and non-fundamental rights was the court's engagement with a political process that was threatening of the court, and so that you get to this settlement. You get to this political settlement, okay, we'll back off and we'll defer when it comes to non-fundamental rights, but we will continue to engage when it comes to certain court-identified, and therein lies the trick, court-identified fundamental freedoms. And I think politically that was rather canny. I think you can construct a political rationale for coming up with that distinction, but as Elizabeth hinted in the beginning, there's no originalist justification for that kind of divide, and in fact it does seem to go against the text of the Constitution. Now, what I would say as an originalist, I think that it's this bifurcation is partially justified and partially unjustified. And it goes to what the Ninth Amendment is talking about when it comes to retained rights, the retained rights of the people. It makes this declaration that just because we've restricted certain powers on the federal government in the Bill of Rights, the First Amendment, Second Amendment, all the rest of them, just because we place certain restrictions here, that shall not be construed in a manner that denies or disparages others retained by the people or other restrictions on your power retained by the people. So it's a statement about the power. It's a statement to think, don't think that your power is otherwise unconstrained, other than the specific constraints that we've listed in the Bill of Rights. That would seem to imply something along the lines of what Randy has talked about for some time, this presumption that the federal government always has to justify its exercises of power, always has to justify its exercises of power. And the presumption is that they do not have power to act in ways that affect our liberty interests unless they can provide some type of substantial justification, whether the liberty interest is fundamental or not. Now, how that would play out, how does that cash out? Does that lead to strict scrutiny? Maybe it does, maybe it doesn't. what degree of justification, how closely associated must the means chosen be to the enumerated end. That's going to have to be played out. That's going to have to be litigated out through the crucible of litigation over time. But I certainly think that it places the burden on the government to always justify its exercises of power, regardless of what kind of right is in play. So that's where I think this distinction between fundamental and non-fundamental is incorrect and non-originalist. Where I think it is very originalist and very important comes in regard to constitutional restrictions on the states. The Ninth Amendment, and again combined with the 10th Amendment, suggests that all powers not given into the hands of the national government nor denied by this Constitution to the states are reserved to the states respectively or to the people. And what that basically, it's a very easy statement. Everything we haven't given away, we retain. We, collectively, we retain on a national level. And you know, the way that plays out, and you get this in Barron against Baltimore with John Marshall saying, the states therefore are unconstrained unless there's some type of express restriction placed upon their actions somewhere in the text of the Constitution. You get Justice Case in Calder against Bull, opening his opinion. By the way, you don't read this opinion a lot when you discuss Calder against Bull, but his opening statement in Calder was, the only restrictions on the states are those which are expressly, or the states retain everything except those which are expressly delegated away into the hands of the national government. That seems to suggest then, when it comes to judicial constraints placed upon the states, there must be a distinction between those constraints which the Constitution has affirmatively placed upon the states and those other areas which are left to majoritarian control. I think that that could very easily and perhaps very appropriately turn into a bifurcated analysis whereby there are certain rights that the Constitution has removed from state control and other issues which have been left and to which the court should defer to local majoritarian control. Now, my distinction between fundamental and non-fundamental rights when it comes to a state level, I think is very easy. Those rights which the Constitution affirmatively constrains the states should be treated as a fundamental right constraining the states. Everything else should be left to the political process. And I think that that is an originalist perspective. So when it comes to the federal government, no, I think it always has to justify its exercises of power. When it comes to the state governments, I think a bifurcation of some kind is originalist, can be justified through originalist methodology.
So two takes, one's an originalist answer and one's a normative answer. From an originalist perspective, I think the textual hook for your question, or the hooks for your question, have to do with the way rights were understood when the Bill of Rights was ratified and the 14th Amendment was ratified. But I think more important, the passive verbs used in all of the different phrases declaring the rights. So an individual right was understood to be a negative liberty protecting a moral power to do something consistent with other people's having similar moral powers to do the same, and is qualified by the genuine public interest. And some of the quotes that David put on the board from the police power cases said this. Even if one is skeptical about Lochner, if you look at phrases like Congress shall make no law abridging freedom of speech, you have to understand that freedom of speech has an internal limit because it's got to be a certain kind of legitimate speech, and a law that abridges speech is a law that restrains speech without regulating it for a proper public end. And similarly, if the right to bear arms shall not be infringed, there are some reasonable regulations of the right to bear arms that are not infringement. And similarly, if the government shuts down a still to stop the still from putting out an immoral substance of alcohol, that's not a taking of property, that's a regulation to prevent a threat against the public morals. So all declarations of right in the 14th Amendment and the Bill of Rights or the kinds of ones that you'd focus on, have built-in police power limitations. And so then the way to ask your question textually is to ask, is there any reason to think that the police power escape hatch built into abridged, infringed, abridged again, is going to vary for the First Amendment right to free speech to the right of peaceable assembly to the right to bear arms? And I think the answer is no. So then normatively you'd then ask, is there some reason to think that when a judge is trying to work out the parameters of responsible, legitimate police regulations and legitimate exercise of rights that have been restrained, is the reason to think that judges might really colossally mess up in one versus the other, or that there's more of a risk that states would overstep in one versus the other? And as a first cut, I'd say no. And I mean, two cases So there are just error costs running both ways. So in the last decade, if there's ever an enumerated right, I mean, the takings clause is one of them. The takings clause, it has a public use clause built in, and Kelo seems a situation in which the government was taking for a not public use. And if the benefits of the project were so great, then why was the project closed within a few years of the Kelo case? And why did the project have such bad cost for overruns and everything else? So there's a situation where deferential court review could have politely euthanized the project that needed to be terminated. On the other side, like a recent, this one's probably more controversial, but the last Supreme Court term, the court considered a case Brown versus Entertainment Merchants that restricted access of minors to buy or to rent violent video games. And some might reasonably think that a state has a legitimate morals interest in stopping youth from habitually playing games that encourage them to kill people and get as much blood and gore on the screen as possible. And it's revealing where free speech doctrine is now, that justification was just barely made mentions in the briefing. Most of the focus was on whether psychologists could show with concrete, specific clinical or control blind testing that people who play games like these would be more likely to be violent 10 to 15 years out. And that to me is the case where the error costs are too aggressive judicial review are stopping a morals law that at least ought to get more hearing. I don't know if it was the right answer to say the law was valid. I probably think it ultimately was. I think reasonable minds can disagree about that, but the Supreme Court's opinion suggests reasonable minds could never disagree about that.
Okay. I'm going to ask one more question, and then I'm going to throw it open to the audience, because I want to get hopefully some sort of juices flowing and some thoughts going with regard to the second panel, too. So I wanted to see if I could get these panelists to focus just for a second on healthcare reform. And Eric, this may be a question particularly for you, because you're talking about sort of the two-track way to approach judicial engagement. There's sort of the litigation track and there's the political track, right? And you were suggesting that maybe in your examination, the political track is more effective. But when you have something like healthcare reform, where clearly, I think the most recent poll, I think it was a Gallup poll that showed that the majority of Democrats, even, I think it was 56%, believe that the individual mandate is unconstitutional, and then of course the general population numbers are even higher than that, where it's immensely and continually unpopular with the American people. And it's one of those instances, too, where it's not just a matter of limiting the scope of federal power, but individual liberty is at stake. And that's Kurt's point about Bond and how important Kennedy is in this case. But given the different dynamics involved in healthcare reform, prognosticate a little bit about how you think the outcome might be based on your philosophy that you've espoused here. And what does that mean for this relationship between limitations on federal power and individual liberty? If we get Kennedy playing a significant role in this case like we think we're going to, what do you think the vision of federalism and its relationship to individual rights is going to be?
I'm glad you asked, Elizabeth. No, I said I wasn't going to tout my own scholarship, but since you've asked, I published a piece last year in National Affairs called Obamacare and the Limits of Judicial Conservatism. It's on the National Affairs website. Google Claeys Obamacare National Affairs and you find it. And in this piece, I reject many of the premises in your question. I do not think this is going to be, this could be a 5-4 case in which Kennedy's decisive vote. I am suspicious. I hope it's that close. As a lawyer trying to predict what the judges will do, I am much more skeptical that many of the judicial conservatives will vote to invalidate the mandate. And I say that because they have the characteristics of the judicial conservative or the post-New Deal judicial conservative that Randy mentioned in his opening remarks. So I think it is possible that, it is possible for a 5-justice majority to declare the mandate invalid. And to me, the way the opinion would be written would be the way in which the Stern versus Marshall opinion about bankruptcy was written, or the way in which the Peekaboo case about the separation of powers and the president's ability to remove executive branch officials would be written, which would be to say, according to the original meaning of the Constitution, the Commerce Clause means interstate trade, and the Necessary and Proper Clause has allowed Congress to expand these limits, but no case has used either the Commerce Clause or the Necessary and Proper Clause or the two together to allow the federal government to mandate that somebody buy a commercial service that he does not want to buy. So since no case covers this, it's unconstitutional under the original meaning. I think it more likely that the 4 liberal justices and some of the conservatives will use Gonzalez versus Reich and Wickard versus Filburn to say the Commerce Clause has been long read for 60 years more in running to say that Congress may regulate anything under the Commerce and Necessary and Proper Clauses, that Congress could rationally believe that when practiced over and over again by millions of citizens could undermine Congress's legitimate policy goals in relation to interstate trade. Congress has goals that health care be provided at an affordable level, health insurance be provided in an affordable way, and the mandate of a purchase of insurance is enough like the growing of the wheat in Wickard and the growing of the marijuana in Reich that it's just not that big a stretch. So then, I guess to me then, does that make like the judicial track fruitless? No. But to me, the primary benefit of the judicial track is to teach people there's never been a law like this, and to teach people in public opinion, and to teach partisan leaders, and to teach legislators make them think about what the Constitution might be and how the Constitution understood as a political document forcing us all to live with each other, notwithstanding our deep differences, how you might fit a law like the individual responsibility requirement into that broader matrix of opinions and settle it in relation to those. So to me, the judicial engagement is good as a way to provide teaching moments for civic engagement.
Although, will there be anything to teach after that? I mean,
well, look
I wonder, like, how do you stand up
Kelo.
in front of constitutional law?
The best thing that ever happened to Institute for Justice, though, is Kelo. They lost, and they lost in the best possible way.
Right, but at that point, I mean, if they uphold the individual mandate, there's no opportunity for the states to experiment at their level the way there was in Kelo. So, I mean, under the Supremacy Clause, it's game over, right? So you don't have that opportunity to go to your state legislators and say, you can work around this individual mandate. There's no workaround.
Repeal.
I want to take this opportunity in part to take issue with what Eric said earlier, which relates to this, and we'll also expand this a little bit, which is he suggested that basically the New Deal court, the pre-Roosevelt New Deal court, was an utter failure because it ultimately lost. And I think that that's overly simplistic because they did invalidate the National Industrial Recovery Act, which in the post-slavery period was the single worst, most totalitarian, whatever horrible adjective you want to give, giving the federal government plenary power over the prices and wages of every goods and service and employment contract in the United States, and that never came back. So hooray for the pre-New Deal court, the pre-Roosevelt New Deal court for doing that, and it also gave time. It also meant that the Roosevelt administration had to spend its resources repassing parts of that, as the Wagner Act and the FLSA, the Fair Labor Standards Act, and repassing also the Agricultural Adjustment Act, and they couldn't be doing further damage while they were doing those things. And by the time they got that stuff passed, it was already 1938, and the country had sobered up a little bit and didn't want any more of these laws. So they actually restrained things, which leads to a broader point, which is that there's two different times when the Supreme Court may be intervening with federal legislation. One is when there's a new ideological wave in a crisis time, or, I mean, New Deal period is interesting because it was both a huge economic crisis and it was the cutting edge of the time when classical liberalism, classical conservatism was completely dying out intellectually in favor of New Deal liberalism. And in that kind of circumstance, all the court could do is slow things down and say, okay, do you really want to do this? Do you really want to do it exactly the way you did it? And if it turns out, and the New Deal period was then unique also because the second crisis, World War II, which was a very bad time to be opposing big government. So that helped institutionalize things. Okay, they couldn't stop that wave, but they did slow things down. The other time that the Supreme Court could intervene is much more similar to the current situation with regard to the ACA, which is when there was a law passed by a dying majority, and that majority has now since died and is not coming back anytime soon. And it becomes that you had a historical anomaly where you had one of the most incompetent administrations in American history who, in a terrible economic crisis, with a horrible political candidate, with the Republican Party having abandoned its own ideological assertions of limited government, and you had so you have a wave of what appeared to be very momentarily a new ideological wave of liberalism, but turned out to be a blip. And the Supreme Court could then say, okay, if we overturn this law, it's not coming back, and we're not going to pay much of a political price for it. It's not unpopular. And I think that could be very effective. I don't think anything like the ACA is going to be coming back. I think, in fact, if we have President Romney, we'll have what we should have had to begin with, which is give all 50 states waivers from all their Medicaid and other health restrictions, and let them all experiment and see what actually works. It's instead of having the federal government take over further 17% of the economy. So I don't take the lesson of the New Deal as the government, as the Supreme Court can have any effect. It can have a limited effect when it's faced with overwhelming trends against it. And that's not the situation today in any event.
And just briefly, right? Because in terms of prediction, just to put my cards on the table, I think they'll probably uphold it because I'm a pessimist, and that's as far as I'll go. I think if they do strike down the mandate, it'll be because of Justice Kennedy leading the way along the lines of his analysis of federalism as a protection of individual liberty. But I think I really have to say, I think the justices of good conscience and good faith can go either way on this one. And I think we should credit Randy for making that obvious, that there really are good arguments on both sides of this. The role that politics is going to play, I'm not exactly sure. I'm not one of those who thinks that the court is going to be necessarily swayed by the political opinion of the people. In my personal encounters with judges, they seem to be mature and strong individuals who don't mind making people mad every now and then. But I'm not going to deny the political science literature that says that they pay attention to elections, things along those lines. I just wanted to just briefly say, because I want to open this up to questions, I just want to remark on what an extraordinary thing it is that we're talking about. We're about to enter into a week of substantial oral arguments in which a court of unelected institutional players are going to decide whether or not to strike down what, from all accounts, is a fairly major piece of legislation passed by the people's representatives. And you can look at this is a remarkable thing. This is a remarkable thing, and I'm not cutting either direction by setting it up that way. From one perspective, this is a ludicrous thing to do, right? The people's will is expressed through the people's representatives. The people's representatives, it's a messy process. Yes, it's like making sausage, but welcome to life. The people's representatives pass this particular bill, and if people don't like it, you can throw the bums out at the next election, right? What the heck are the courts doing? Thinking that they might have the authority to strike down this law. And that goes to the point of why do we do this at all? Why are we playing this game? Why are the courts there at all to exercise judicial review and at least issue the threat, even if they're not really going to use the threat due to political valences? Well, it's because of a particular theory of the American Constitution. And the theory of the American Constitution is that the government is not the people. The people express themselves. It's a peculiar system. The people express themselves by way of a written document, which their representatives are then obligated by oath, by fidelity to that document, to uphold regardless of the political winds. Right? It's an unusual theory. Not all democratic governments follow this particular approach. Not all governments give the extraordinary power of judicial review to the courts that we do. But I think it's worth pausing just for a moment as we enter into this week about what a unique and extraordinary thing it is that's about to happen, and think about what justifies it, because I think the only thing that can justify it is if the court strikes it down, it would not be because of their political preferences, but because in good faith they believe they were upholding the will of the people, regardless of the political winds. And I think one way or another, they owe us an explanation, a clear explanation, whether they uphold it or strike it down. A clear explanation about how their opinion reflects the considered will of the people themselves and not simply the political exigencies of the time.
Okay, that's excellent. Please join me in thanking our panelists one more time. I think it was terrific. And we do have about 10 minutes.
Judicial engagement is necessary. It's a necessary part of the ongoing sort of political dialogue that he is talking about. And in order for there to be judicial engagement, there has to be a certain background rule of constitutional law that allows the courts to be engaged. You could take the Kelo case, for example. If, in fact, the Mitkiff case had actually said what most people thought it said, which is that you have no shot, no way, no how, there is no case, there would have been no Kelo case to outrage people when it was wrongly decided by the Supreme Court. In other words, you would never have gotten to the Supreme Court because every lower court would have said, you know, you're just out of here. And there would have been nothing for the Supreme Court to take. It was the virtue of the Institute for Justice Litigation Strategy that they developed a sort of novel theory of public use for private developers' takings or whatever they called it, that got them enough novelty to get them in, notwithstanding Mitkiff, and they got them to the Supreme Court. Similarly with our case, the Affordable Care Challenge. If there hadn't been for the mandate, and of course there's the Medicaid challenge too, which is another matter, but if it hadn't been for the mandate, we wouldn't be in court. And if we weren't in court, there wouldn't be any national dialogue about the popular constitutionalism of making people buy these purchases. And after this case, if we lose this case, in the future, we will not be in court. There will not be any future popular dialogue about constitutionality. So what does that tell you? I mean, we've got this sliver of a 2,700-page bill that we can challenge because it turns out Congress has never done this before. Therefore, it's unprecedented. Therefore, we have a chance to get in court and decide. But with respect to, for example, in running the insurance companies, which is what the bill does, we don't have a viable challenge. Therefore, we can't have a public dialogue over whether Congress should be running the insurance companies and basically eliminating private actuarial-based insurance. We don't have that dialogue now because we've got no legal theory on which to challenge that. So the premise of the political dialogue, and by the way, I agree, the Supreme Court or other courts are just not going to get out that far ahead of public opinion, which is very much why this bill's tremendous unpopularity, as well as the popular sentiment that it's also unconstitutional, is crucial to the background of this interaction, which is why you have to have at least a constitutional theory that would get people into court, be able to question the rationality of the laws that are being imposed upon the people, and then we can have that national dialogue, and then the courts can rule against us when they rule against us, and then there can be a backlash to the courts ruling against us when they do, but there's not going to be a backlash to a judicial decision that's never made. And it's never made because basically we accept the judicial conservative position that the courts have no role to play. So this is an affirmative argument for why there should be judicial engagement. I don't think anybody here is under any illusions that judicial engagement means you win in the courts, that's it, you've won. That's just not the way it works, but I think it's totally unrealistic to think, with no foothold in the courts, you will then have the kind of judicial popular constitutionalism dialogue that is necessary to protect liberty and to protect the Constitution and to move the general public in the right direction. I mean, the last thing I will say about that is that with respect to this mandate and with respect to this bill, the lawsuit itself has accomplished, even if it loses, the lawsuit has accomplished something that you couldn't accomplish without a legal foothold, and that is, it has called the legitimacy of this law into question in the minds of the general public for 2 years, leaving the political process enough time to generate, first of all, a flip over in the House and now a presidential campaign in which every presidential candidate for the Republican side says they favor repeal. In other words, the only way we got to the political process to correct this, let the political process correct this. Well, if the political process was not going to correct it, if this bill had been accepted as legitimate 2 years ago, it's only because its legitimacy has been questioned for 2 years that it's now there's still a political possibility of repealing it. And that's something, again, that was created by the possibility of a judicial engagement with this act, regardless of how this case comes out. So I'm just urging you, Eric, and by the way, I think that's one of the reasons why your prediction in that article a year ago was somewhat unrealistic when it was made. And it remains, it's more unrealistic today than it was when you made it. I think I'm urging you to be more realistic in your realism about the role of the courts in engaging the general public in what is constitutional and what is not.
I believe Sandy, you had a...
Yeah. I take it that one thing that everybody in this room agrees with is that you cannot possibly explain the history of American constitutional development over the last 225 years in terms of our favorite theory of what the Constitution means. And what that also entails is that there are decisions we would gladly overrule. As it happens, I wouldn't at all lament if Williamson versus Lee Optical Company had gone the other way. I think that Randy makes a very strong attack, but precisely because it would be so fact-intensive on the particular case, in the great scheme of things, it wouldn't matter that much. But the real question I guess I want to direct at Kurt, and because of time, and this goes back to the debates we had at Illinois last year, you're very critical of chartering the bank. You valorize Madison, and I won't bother saying, well, what about Hamilton? Let's assume that Madison's absolutely right. He loses. He loses not only in Congress, but then, of course, big time in McCulloch versus Maryland. So the really serious question is whether you would overrule McCulloch. And Mark Graber, incidentally, says that if a Whig Congress had in fact had the votes to charter a bank, had been able to override Jackson's veto, then a Supreme Court by that point would have overruled McCulloch.
Yeah.
But the reason McCulloch sticks is that in fact it's never seriously challenged thereafter. The other case that I'm curious about is Hammer versus Dagenhart, because it establishes the legitimacy of the national police power. And for federalism buffs like yourself, that should be a problem. So would you, in fact, have an engaged court based on originalism or whatever theory is your favorite theory? I really don't care. Would you have the court seriously call into question or out and out overrule Marshall and McCulloch, including, incidentally, the part 2 of McCulloch that deprives the so-called sovereign state of Maryland of the ability to tax the bank? And would you have a court in 2012 say that Justice Day got it right in Hammer versus Dagenhart? Forget the New Deal settlement. Part of the New Deal settlement is to overrule Hammer.
Right.
Were they
Darby,
correct in doing so?
Darby,
yeah.
Right. Well, I'll stay with Madison on this one. He said he did lose in terms of the initial charter. In terms of whether or not he won or lost, ultimately, we can talk about Jackson. We can even talk about the first time that he won when they first tried to re-up the bill, I think in like 1810, right? Something. In 1811, when they decided not to re-up the charter of the Bank of the United States, they cited Madison's argument, his initial argument that he was initially unsuccessful in pressing before the House. But it's a question about precedent, right? If you're going to follow your theory, if you're going to be an ivory tower academic and follow your theory that makes everything work like clockwork, right? And destroy everything in the process, right? Just getting to your clock, just getting to what it is. Well, Madison's point on that, I think, was fairly pragmatic. He continued to insist his whole life that the reasoning that led to the chartering of the bank was wrong, was simply wrong. And it was on federalism grounds, this idea that you had competing sovereignties, and keeping them as competing sovereignties was ultimately going to lead to more liberty for the people down the road. As far as the bank itself was concerned, Madison was reconciled to it. He signed the second bill, signed the bill that brought the second bank into existence. But he did so as a matter of political precedent. He said, the institutions of government have accepted the existence of the bank for so long. I'm not going to let my continued objections stand in the way of the bank. And when he objected in McCulloch, in his detached memoranda, when he was writing against McCulloch, it wasn't so much because he thought there shouldn't be a Bank of the United States. I mean, for all I know, maybe the War of 1812 really did change his political preferences regarding the existence of the bank. It was the reasoning of McCulloch that he objected to. And the reasoning of McCulloch denied the existence of any separate sovereignties. There was no dual sovereignty in McCulloch. There was a single national sovereignty. And with a single national sovereignty, there was no longer any reason to constrain the political judgments of the federal Congress in any matter that had to do with extending into local government. He thought that that was exceedingly dangerous. So as a matter of politics, he was willing to allow the bank to go forward. But the reasoning, from that point forward, the reasoning of McCulloch should be abandoned, right? And I think that that's pragmatic, and I've written about this in terms of stare decisis. So when it comes to, say I have a theory that states some major happening by the court or by the political process was just wrong. It just doesn't follow the original understanding of the Constitution. I think that it's perfectly possible under democratic theory to accept the existence of erroneous precedents that where the error does no more than leave something in the political process that maybe the Constitution wanted to remove from it. So the error, whatever error it was, left the people more decision-making authority than the Constitution would otherwise give to them. So it gave more, say you give more power to the federal government than they were supposed to have. They were supposed to have more constrained power. But at the very least, the exercise of that federal power can still be controlled through the democratic process, only now at a national level as opposed to a subnational level. I think it's possible, along with Madison, to make peace with those kinds of decisions, as long as you continue to insist that henceforth, we abandon the reasoning that led to that error and stop making errors in the future. And if we continued the discussion, I think I would follow Madison probably. The reason why I take that position has to do with rule of law values that I think are part of the constitutional project altogether. You don't want to destroy things and you don't want to destroy the village to save it. So I would probably accept the bank. I might even accept Darby. But I believe as an originalist you could not possibly accept the rationale that led to those decisions. It's a partial answer. Right?
But I think you've hit the nail on the head in the sense. I mean, this is why, you asked if I'm an originalist. If I was in 1791, I'd probably be an originalist. 2012, with a lot of water under bridge, once you have, Kurt is an academic, and even as an academic, he's not willing to say he overturns Darby, and the people who are actually on the court who claim to be originalists. So you have Justice Scalia. Well, I'm not going to go back to an original meaning of the Commerce Clause. My originalist views of incorporation are very different from what's going on now. I'm not going to do anything about that. I don't think women are entitled to equal protection as an original matter, but that's too late too. So everything up to about 1970, it's too late. But only a few things that I really dislike politically since then. Then I'm going to be an originalist on that. And that's exactly what you'd expect the way our system is set up. You can't really go back and reinvent the wheel. And I find it unoriginalist to say, well, it's too much water under the bridge. Well, that's not an originalist theory anymore. Everyone, as I tell my Con Law 1 students, everyone is an originalist to some extent. No, I don't think there's any justice who ever said that I will completely ignore what we think the Constitution meant. I just take that into account. But once originalists, like Scalia and maybe even Kurt, say, well, I'm also willing to take into account what's happened, but I just put less weight on it than my liberal colleagues. Well, then we're all on a continuum of originalism versus non-originalism, and it's really not true originalism versus non-originalism as the dichotomy.
Well, and just as a quick follow-up to that, because I think that's perfectly fair. One, notice where I would not leave room for precedent. Any erroneous decision in the past that takes something away from the political decision-making authority of the people, I think, is per se up for de novo review. So whatever those precedents are, I don't think you defer to them. As to why you would leave room for others that erroneously left it in the political process, well, why am I an originalist? I'm an originalist because I believe in the project of popular sovereignty. I believe in the project of popular sovereignty due to the normative political theory of democracy, self-rule. There are two forms of self-rule. There's a European parliamentary model where self-rule would come by way through the ordinary political process. It's a fine model. Maybe it's even a better model. There's another model that says that you can even get closer to the will of the people by way of this supermajoritarian process that could reduce things to a written constitution. So I think so my normative reasons would say we should always defer to the people and the constitutional project of supermajoritarian popular sovereignty. It's a second best theory that would say if errors do no more than leave it, put it back into the political process, I'm still being faithful to why I want to be an originalist in the first place, because I'm still trying to leave things as a matter of self-government. But if the error takes it away from the people altogether, that error should always be up for review. So.
with that, I'm afraid we're going to have to wrap it up so we can stay on schedule. Thanks again to the panelists. It was a fantastic discussion.
Well done.